Okay. Hello, everyone. My name is Riley, and I am the Digital and Social Media Content Analyst here at GBBC. And it is my pleasure to introduce the first edition of Hot Topics in Blockchain Law, a virtual roundtable presented by the International Journal of Blockchain Law, a GBBC initiative. And the International Journal of Blockchain Law, also known as IJBL, is an open access online journal written and edited by lawyers and designed to help businesses and non-legal communities better understand the world of blockchain and digital assets. If you want to check out the IJBL, we will be sharing a link in the chat shortly. But now I will turn it over to GBBC Chief Legal Officer and Head of Policy Americas, Andrea Tinianow, to introduce the speakers for today's roundtable.
So welcome everyone and good morning and thank you for joining us here today. Everyone else is on mute too. I guess it was automatic. And so this is our first edition of Hot Topics in Blockchain Law. I'm Andrea Tinianow, and I'm going to ask each of our participants here today, all blockchain lawyers, to tell us who they are. David, why don't you start? And then Sarah and Jason, Christine.
Sure. I'm Dave Adlerstein. I'm a corporate transactional lawyer at Wachtell, Lipton, Rosen, and Katz. I've been in crypto for some years, and I'm a member of our firm's crypto team. And I would also like to say for the record, despite what the Zoom background is doing to me, I more or less have normal ears.
Okay, Sarah.
Hi, I'm Sarah Brennan. I'm General Counsel for Delphi Ventures and Delphi Research, which are two distinct companies, and I'm a contributor at LexPunk.
Hi, everyone. Jason Gottlieb from Morrison, Cohen in New York. I chair our white collar and regulatory enforcement practice, as well as our digital assets practice. So I spend most of my days in the intersection between those two things.
Christine.
Hi, Christine Parker here, Deputy General Counsel at Coinbase. I head up the legal regulatory team. In my prior life, I was in private practice and focused on commodities and derivatives regulatory and enforcement matters.
Stephen.
Hi, my name's Steve Palley. I'm co-chair of Brown Rudnick's digital commerce practice. Most of my practice is focused on disputes, regulatory advice, and government enforcement defense, generally at the intersection of crypto and financial regulatory matters.
And please, Eric. Can
everybody hear me?
Yep.
Okay, sorry, I was a little late to this, so I'm catching up. So I'm Eric Hess of Hess Legal Counsel and the host of The Encrypted Economy. I cover, I'm an ex-TradFi secondary markets securities guy, was a general counsel of a stock exchange. So, that's often my perspective when I enter this space.
Thanks so much, Eric. Eric, I have a few housekeeping items before we get started. First of all, I want to make sure everybody understands that the comments that we make today, these are our own opinions. These are not the opinions of our employers, the organizations we work with or for. So I just want to make sure everyone understands that. That's really important. That's our blanket disclaimer. The other thing is we've structured this time today as a conversation. It's a conversation between all of us here on the screen, but also all of you who are listening in. There's a chat, a Q&A. We encourage you please to share your questions and comments, and we'll do our best to respond. We'd like to keep it that way. We hope you'll be engaged with the content and with us. And let's see, finally, we will be talking about legal issues of the day in the blockchain world, and we also are going to raise some ethical issues and questions. So if you happen to spot an ethical issue that as well, please send it our way. We love a challenge. So with that, we will start with the news of the day. And unfortunately, the news of the day, I'll just use this. This is my prop. I have one prop, the cover of The Economist. And the news of the day, you can't help but avoiding what's happening with FTX. Of course, the facts are unfolding. We note that there's the latest is a jurisdictional dispute. We suspect that most of you who are watching have a pretty good feel for what's been going on. That there's been a a bankruptcy filing here where I am in Delaware. There's as well liquidators in Bahamas who are trying to move the bankruptcy to, to take, they want to be in charge. But what, with all of this going on, so many facts unfolding, what are some of the legal, what are the legal takeaways? And I want to just throw that just to open up to Dave Adlerstein, to if he can give us some thoughts there. And then everyone, please feel free to chime in.
Yeah, the facts are still unfolding. I mean, at least from where we stand now, this looks like it's crypto's version of Enron, but I think there are a few salient points that I'd like to make. One is the magazine cover you held up said it's crypto's downfall or failure. This was actually not a failure of crypto itself. The technology, Bitcoin, Ethereum, a lot of protocols are functioning exactly like they should, and it's not a failure of the underlying technology. What this has been a failure of really is of centralized institutions. And in fact, the whole ecosystem that allowed FTX to thrive and allowed SBF to be like sort of the poster child for regulation, the investors who kept him going without a lot of effective diligence, evidently, although hindsight is 2020. So I think it's important to differentiate between the failure of crypto and the failure of centralized institutions, which ironically is the very point of crypto. Like if you go back and read the Satoshi white paper, you're trying to eliminate central points of failure. So that's one takeaway. A second takeaway, I think, is very, very clearly there was like an abysmal situation here of a lack of internal controls. And I think that there will be a regulatory response where any centralized institution that's involved in custody or functioning as an exchange, DeFi is another kettle of fish, which I'm sure we'll come to. But for centralized institutions, I would expect there's going to be a significant regulatory effort to prevent this kind of thing from happening in the future. I would expect Christine will have more to say about that. And I think a third important takeaway is FTX International, at least, was offshore. They were in the Bahamas. I'm not saying this to disparage Bahamian regulation, which from what I understand is actually, not a bad regulatory regime down there. But I think we want to avoid a situation where crypto is viewed as so toxic that it's all driven offshore, because ultimately that will not redound to the benefit of either the growth of the technology, U.S. leadership over it. We need balanced regulation in the United States to keep people here, but in a way that's safe. And I'll turn it over to others.
Thanks so much, David. Christine, did you have a thought on that?
Yeah, I did. One thing I want to say at the outset is that even if you have sort of best-in-class regulations in place and you have sort of top-notch regulators that are all over it, it is really hard to stop a bad actor, sort of a rogue actor within an institution. You can go back, you think about MF Global, all the right controls in place, and you have a bad actor who sort of, understands them and is determined to circumvent them. So that is certainly like a challenge that I think the regulators are cognizant of. Obviously there's there's a lack of federal oversight in the U.S. over commodity spot markets, and so that's something obviously that policymakers on the Hill are looking to fill in with proposed legislation. I assume the legislation isn't going to move this year. I assume the policymakers are going to sort of take their time, try to understand some of the repercussions from what has happened here, and sort of make sure, sort of pressure test legislation to make sure that the conflict of interest provisions, the bankruptcy provisions, all would have been mitigants to sort of the disaster that we see unfolding before they push forward with the legislation. So that's my guess on DC. And also, obviously, the outcome of the elections, it was very narrow, divided House and Senate, so that sort of relieves some pressure from Democrats to get something done before the new Congress, but also presents challenges for the new leadership in the House to coalesce around a policy position in the space. So I'm hopeful in the short term that there's not going to be this sort of massive regulatory overreaction. I'm hopeful that, as you see what unfolds with FTX, the policymakers will look at the legislation that they have, sort of determine if it was sort of fit for purpose, and then sort of make tweaks to address whatever sort of issues were outlying that weren't covered in the legislation, but without sort of this sort of massive sort of overreaction that would, in many ways sort of doom both CeFi and DeFi. But it's the end of November. Ask me again in 2 weeks and I probably have a completely different
And
answer.
when we talk about Cefi and DeFi, for some folks who may not be as entrenched in the space, Cefi centralized finance and DeFi decentralized finance. And the question is how should they be regulated? How should centralized actors be regulated, involved in the crypto space, and the same for decentralized finance? Would someone like to take this up, Stephen?
Yeah, so I see, like, in my mind's eye, I have a schematic drawing of how regulation works for crypto. Currently, you've got basically, I see it as like 3 slices of a pie and then 2 slices underneath it. The 3 slices are securities law, commodities and derivatives law, banking law, and then below it I have the BSA and OFAC, so sort of financial money transmission and sanctions. I think the question is, and this goes both with respect to Cefi and DeFi, the question is, does what exists now correctly or neatly, or is it fit for purpose, to use Christine's words? Do those rubrics work for software-based digital exchange, and maybe even for novel forms of software looking forward? I think we can currently take either Cefi or DeFi and fit it into those 3 top buckets and assume those 2 bottom buckets are going to apply. The question is, do we have a 4th bucket? Is there going to be a new type of regulation? And Christine mentioned commodities law. So the Commodities Exchange Act, that's a creature of the 1950s, right? The question is, do we take that and we say, we'll just bucket everything into commodities law? Now, currently, the Commodities Exchange Act, at least in theory, only applies to derivatives, right? But the CFTC has taken the position that they have jurisdiction over spot market fraud and market manipulations. The question is, do we say, well, unless it's clearly a securities-based swap, it's going to fit into commodities. So I don't think it's going to work that way. I think what we will have going forward is, I think ultimately, and this is not a normative statement, this is more in the nature of prediction or speculation, we'll have a 4th slice. And there will be some form of digital asset exchange licensure and oversight. And then for me, like, what's really interesting is
Stephen, I want to stop you. I want to stop you for a second. Are you suggesting that there will be a new bucket of regulation for digital assets that aren't considered that? So you're saying that for digital assets, period? Well,
I mean, it's worth noting that something can be both a commodities-based swap or a securities-based swap, right?
Exactly.
We can have like a Schrodinger's cat type of digital asset. To me, like, the really interesting thing, and I'm going to stop talking because I just go on and on. I'm fascinated by this. I like thinking about these things and like, I imagine myself 30 years in the future. How will this look? To me, what's interesting, digital assets are cool. I'm more interested in the notion of regulation of technology-based risk. I think, like, you have the 33 Act, the 34 Act, the Trust Indenture Act, which we never talk about, thank goodness, and the 40 Acts. Those things developed in response to sort of the needs and requirements of late 19th century, early 20th century industrial capitalism, disclosures, the Great Depression, but that work was already being done before 1929, both in England and in blue sky, and in states under blue skies laws. And the regimes that were created were disclosure-based. And one of the pushbacks that, if you read the legislative history, people said, well, nobody will understand those things. Why are we doing that? The question I have for technology risks, and this includes things like autonomous vehicles. If I say AI, a lot of people will roll their eyes, but that's coming. The question is, isn't the issue here technology risk and disclosure? And are those things actually appropriate for securities regulators or commodities regulators? So to me, I think that 4th bucket, I think that's sort of the beginning of a conversation about technology risks and considering, and again, I think Christine's, those words, fit for purpose. To me, that's the more interesting question. The problem is, in our divided, between the House and the Senate and the presidency and an election in 2 years, are we going to get there? It's worth noting that the Securities Act of 1933 was 4 years after the Depression, right? The Investment Advisors Act or the Investment Companies Act, those were 11 years. Copyright law, I use this as an analogy, copyright law was 200 years after Gutenberg. So the question is, like, what are we going to get done?
Well, hopefully we will not have to wait 200 years to get fit for
I don't know.
purpose legislation. I want to ask Eric, because Eric is really understands the tech pretty deeply. And I also want to note that a lot of what you were talking about, Stephen, that was contemplated by Article 3 of the Loomis-Gillibrand draft legislation, which has not yet really been taken up. But the idea is that it did note that there should be disclosures about the tech. You know, what do people care about if they're going to be buying digital assets? But I'm going to throw it to Eric, and I'd love to hear your thoughts, and then we'll hear from Jason and Sarah. We'll keep the conversation going, please.
All right, so I'll pick up a little bit on what Steve said regarding AI, because you know, when you look at like the Uki DAO case and the way that the CFTC was framing the potential exposure of the governance token holders, you know, what is the knock-on effect? And Steve really hits on it. He talks about AI. So here's the thing: like you can play whack-a-mole on what you think is a problem today, but the knock-on effect is going to be okay. How do we now change this governance structure so that we can have the you know, whether it's a governance token holders, whether it's a token holders, the passive token holders, we'll just call them themselves. How do we, you know, how can we respond to it in a way to better manage that potential liability? And the coming answer in the near future is AI, because if the regulatory environment forces these holders to step away from having that governance control, you know, it may just incentivize, you know, decentralization, you know, leveraging AI to make those decisions, and just have the DAO members perhaps as controlling forces surrounding it. So you know, the you know, the way that we regulate can often be very fact specific, right? Like, you know, FTX, we have to respond to what happened to FTX. We have to respond to this narrow box. But I think the regulators, particularly in the US, less so in Europe, honestly, have not had the vision of you know, what is the framework for regulating it? How do we regulate in a way that achieves outcomes ultimately that we do want to achieve? And contemplating even the, you know, this notion of AI factoring into governance probably wouldn't be a terrible idea versus having to respond and have all these questions in years from now. So that's sort of a broader picture issue. Europe has done a far better job of contemplating the use cases for AI and the need to engage in algorithms that manage private information, et cetera. These are all important considerations, and the decisions that are made, and whether they are potentially discriminatory and biased. These all factor into the same equation. The other point I want to make really quickly about FTX is, you know, often lost in this is that you know, in the U.S., FTX U.S., there, you know, you have the UCC that protects the you know, specific provisions that protect you know, either commodities, brokers, FCMs, et cetera, those balances held on behalf of customers, as well as if there are equities. So if there's equities held in custody, if there's futures that are held in custody, those have specific provisions protecting them under the UCC, and they would be segregated. They would have you know, they would receive beneficial treatment as part of the overall bankruptcy. They're protective. That doesn't exist, obviously, as you move offshore to Bahamas. And so one of the things that, you know, needs to be contemplated is that, you know, those that chose to open U.S. individuals, U.S. companies chose to open accounts in Bahamas, chose to avail themselves of the judicial system in Bahamas. They chose not to avail themselves of the protections of U.S. laws. And so when, you know, when legislatures
so they get what they get, because
they get what they get, and it may not be popular. People say, well, I shouldn't be held responsible for my own actions, but the fact of the matter is, you know, if you are a U.S. resident or a U.S. company and you choose to avail yourself of foreign laws, you're basically making a choice. I don't want to be protected in the U.S. That's a fact. That's something that some of this debate, I think, has lost.
That's really thank you so much. Jason, did you have any further thoughts on this question? Anything that you wanted to raise?
Yeah, and I'll trying to tie together some of the comments here. When we're talking about regulations or new regulations, it's important to ask, what exactly are we regulating? We've heard, you know, different folks say we should be focusing on regulation of the technology. I think the regulators we have are largely focused on financial risk of various kinds. And to a certain extent, it's paternalistic. They're trying to limit risk for retail or unsophisticated players because nobody, wants a retired teacher to lose their entire retirement account overnight. To a certain extent, that counsels to say, well, okay, we can be a little bit paternalistic for some people, but not others, and we'll have different rules for rich folks or institutions. And that's kind of what we have now, although then you have to face the systemic risk problems as well. Because if you let lots of institutions gamble and they all lose, then you have contagion issues that could spread. And we saw that in 2008. So, we have to ask ourselves sort of what are the goals and how do we get from here to there? The practical question here is important. We can use the current laws, the existing framework, and just try to, pencil in some line edits to add in digital assets. I think that's possible and a lighter lift, but it's harder because you have to really make sure you're taking account of the technological advances that we have. You can't just say, oh, and we'll count digital assets as securities or as commodities and call it a day. Because the rules and the regulations that we've built up over the last 90 years don't really fit very well. And there are a lot of unanswered questions about how they would apply to those things. I like Steve Palley's idea about needing a new digital asset specific law. I think that's right. I think it's necessary, but it's also very hard, right? It's a hard lift to get the divided Congress, as he said, in a busy political climate to focus on starting from scratch and writing something very new. But here's the thing, we have to do one of the two, either completely overhaul the old stuff or come up with something new. Because to the extent that we have a system where people just can't do this, they can't offer tokens, they can't trade tokens, they can't use digital assets as software in the many different ways they want to use them for fear of running afoul of all the regulators, we have a technology that does not respect borders, that can be done from anywhere, that can be done fully anonymously and will be done fully anonymously. So, regulators face this risk of either fixing the problems we have, or you're going to have many more people doing things offshore and anonymously. And, maybe to Eric's point, who cares? People can take their risks and they can either go with, the Citibank that's operating in New York, or they can go with some offshore anons. And if they get rugged, that's their fault, that's their choice, and they have the right to make that choice. But I think that sort of thing is bad for the US economy. It's bad for the global economy. It's bad for the folks in retail who will make that choice and probably shouldn't be making that choice. And it leads to systemic risk issues where institutions make that choice, and the choices that they make have repercussions that get inflicted on other people as well. So I think the regulators really need to figure it out. And I think we as crypto lawyers in the space need to help them figure it out as best we can. There are, I think, upstream currents because after FTX, a lot of folks in Congress may not want to listen to us, like, oh, you're all crypto and you're all FTX and you're all, whatever. But we have to keep trying, given the goals that we all share.
Yeah, Jason, those are really important comments. I think from what I've heard in DC, folks do want sensible legislation. They do want to see where the risk is, but like you said, it's a big heavy lift to make sure that the legislation meets the current needs, and not just the current needs, but 30 years out, as Stephen was mentioning. I'd like to do two things. I'd like to throw it over the mic over to Sarah and get some of her comments, and then I'd like us to switch gears and talk a little bit about not FTX, but what we're seeing on the ground when it comes to U.S. regulators and courts, and how they are continuing to consider how tokens are classified, and then potentially some alternative thinking on that. But first to Sarah, and then
actually, I don't want to usurp your position as a moderator, but Sarah.
No, of course you can. That's what this is about. Sarah, please usurp.
So Sarah is one of the most brilliant securities lawyers in the space, and I had the pleasure of working with her in a very low-level supporting role, working on a proposed safe harbor, something that would apply to digital assets. And I'm curious, Sarah, I don't know if you want to talk about that, but like as far as practicalities goes, you actually created with folks from LexPunk, you created something quite practical You want to talk about that and maybe talk about sort of that sort of regulatory work, what it would entail, and if there's still hope that can work to something like that. What was it called? It was not Reg X.
Reg X, yeah. Sure. I think like just to, before I get into that, I think like existing law, securities commodities is predicated on intermediated transactions. And like we do have intermediaries in the space, and I think they should be regulated as such. And I agree with everyone, crime is crime. But you know, this tech, like the promise of crypto no longer exists if we just say everything has to be intermediated. And so, you know, I think from a policy perspective, you have to regulate to the risks, as people keep saying. So like, if the paradigm has shifted and that custodial risk doesn't exist, slapping like that type of regulation as if it had, making certain models, more decentralized models, like per se illegal. I think that does real damage to the US taking that stance. It's counterproductive. You're kind of shooting yourself on the foot if you don't offer guidance relief. Like people going offshore choosing to is also, you know, often a false choice because there's been no permissive guidance. And that's the one thing about SPF that I wanted to mention, because he was actually close to getting a no action letter. And that's like the real shame of all of this, is he did play the system well. He was about to get a no action letter potentially on broker dealer custody rules. This is really like enabling guidance that we're missing, right? That's just shooting ourselves in the foot on rule of law. Like you could have some real gains if you could show compliance is possible.
Sarah,
so that's.
Stephen had mentioned some work that you had done, and I was wondering if you could share that with us.
Yeah, I was just responding to the other question. So on Reg X, when you look at what people are trying to accomplish in this space, I think the focus should be a proposal that fairly distributes compliance obligations in the market, being cognizant of the actual interactions between issuer, insiders, whales, and secondary market actors. And Reg X is a mashup of Reg CF and Reg A. So first of all, there's a safe harbor, which is a notice and disclosure regime. If you don't meet that, it's kind of based on sufficient decentralization principles. If you don't meet that and you want shelter from the regulatory storm into doing an issuance, whether that's an airdrop or doing a crowd sale, we have a framework that you would opt into. That addresses policy goals of providing tailored disclosure. You'd be ongoing reporting, kind of like an Reg A exempt framework. We came up with pretty tailored disclosures. And then if you do decentralize, you have the ability to kind of sunset, because it doesn't make sense for a policy perspective to have a group of people on the hook forever when they aren't the knowledge party anymore. And so, you could, and it's just addressing issuances. And so you're not locked into these questions around, is the token a security forever? The issue, you did a public sale for money, just like call it, you opt in, you report when it makes sense for you to report, and then there's kind of an exit ramp. And I really think that is important for, getting people to opt in, and including there's some things that we moved around, like international issuers. It would behoove the US to kind of have everybody in this disclosure framework from a risk perspective, and it not being super onerous, where it's, not this, it's not a one-way decision, right? So that's kind of the premise of it. And then it's a lot more nuanced in that we go into the existing securities laws that need to change and get exemptions for all of this to work. But it was, I don't know, Stephen, like 8 months of work that we put out, and would love people's feedback on the premise and the details and that sort of thing.
Sarah, is the language posted somewhere so folks on this webinar can take a look see for themselves?
Yeah, it's on GitHub, but you can probably just search Lex Punk Regulation X and it'll pop up on Google for you.
Thanks, Sarah. I would like to pivot now. We've got some questions, so we will get to the questions, but I wanted to pivot now to one of the things that sort of underlies really a lot of what we're talking about, and it has to do with the way the U.S. Law treats tokens and the Howey test, which is in large part how digital assets, or I should say, fungible digital assets, currently how courts look at and the SEC looks at whether or not they are not securities. And in just in the last, I guess, week or two, we had a decision come down in the library case, SEC v. Library. But I want to throw to the group here. Client comes to you and they say, you know, we've got this great project. We want to issue a token. We want to do it in the U.S. What do you tell them?
I mean, some of it depends on, obviously I have one or two of these calls a day. So here's the challenge. If you want to, and this is not the Howey test. This is the Palley test, if you will. Which interestingly, Andrea, you're in Delaware. That's how Palley is pronounced in Delaware with the mid-Atlantic accent. People are that. So under the Palley test, look, I mean, what I tell people is if you're coming to the United States, you want to sell tokens to raise risk capital, like to build stuff, and then in the future to have an income stream. That's not the Howey test exactly, but if you're doing that, it's probably an investment product. Here's the problem. And it took me a long time to get this. And it took a while, like most of what people want to do is get easy money, give people tokens. The people who get the tokens want to 10x them on an exchange or 100x them on an exchange. That's been a driving principle, but there's something else. You can use tokens for product. Let's say you wanted to create a decentralized market that allowed people to sell their consumer buying intentions. Like, let's say I know that I'm going to buy a refrigerator. I'm going to buy a refrigerator in 3 months. That information now is harvested from centralized platforms and is sold. There are like 5 different intermediaries. So like the cost or the cost for finding a prospect to buy a new insulin medicine, that's like $1,000. Now, what if we could create a decentralized market that allowed for the sale of those things? It's not my idea. Jerome Lanier wrote a book called Who Owns the Future, where he talks about this. Crypto actually works with that. Here's the problem. If I sell tokens that can be used to monetize user attention or user attention or buying intentions, if I do it the wrong way and I create a security, then the security can't be used on a product platform because you have to have things like transfer agents. You've got 10 different intermediaries. Things have to be
rules. You've got all the federal rules.
Yeah. So the problem is if we, it's not. I know, I get it. Like I know that a lot of people are skeptical about crypto, and absolutely, there's been a ton of ridiculous and irresponsible financial speculation. A lot of people are trying to get something for nothing, but there is a product there, and the problem that I keep butting into is the advice that I have to give people is I see the product, I get it. But if you're selling it initially as a security, whether it's an investment contract or something else, a debt instrument, people forget that the definition of security in the Securities Act or the Exchange Act is broader than investment contract. Those are long definitions. If it fits within it, you can't use it as product in the United States. So the question is like, do you want to raise money or do you want to build a platform? If you want to build a platform, you have to disentangle the software from financial regulatory rails. And the problem is that concept, by the way, that notion of the attention token, and Brave has something like that. And maybe they're the folks who've gotten closest to being successful. There's something sticky about it, but it's really hard. And I tell people, the thing you have to distinguish between is the financial product that you're going to use to raise risk capital and the product. If you really want to build a product, no securities.
Yeah. So Stephen, that's really that's that's pretty darn interesting. I think there's risk issuing tokens in the U.S., especially as you say, it's about receiving raising risk capital. And what, Jason, you're shaking your head. Do you have anything you want to add there?
Yeah, I think it goes then to the ethical question, right? When a client comes and says, we want to issue a token in the United States, how can we do it? I think that the right and ethical thing to do is tell them that under the SEC's current interpretation, you basically can't, right? It's very difficult to figure out a way to issue a token in a way that divides it from the investment contract in which it may or may not be offered. If you're selling this piece of software, of course you can sell software, right? I bought my copy of Microsoft Word or Halo 2, and it's a software. Nobody thinks that that's a security. But we have this funny idea that once you can take that piece of software and kind of trade it on a market, it suddenly becomes a security, regardless. And this was one of the stranger instructions of the library case, the LBRY token, regardless of the elements that you may have been talking about. If you were saying, buy our software and you'll be able to make a lot of money by reselling it, okay, that makes it seem more like a security. But that court seemed to be saying, well, even if you didn't, just the fact that you're holding some of the software for yourself, you're holding some tokens for yourself, will lead people to the expectation that you're going to make efforts that will increase the value of the token. Now, that's what the judge said. It may or may not make sense. If a software development company holds back 30,000 copies of a video game that it wants to sell, does that suddenly make the sale of the video game a security? Like, that would be nonsense. But at heart, the tokens are just software, right? There's not a lot of difference between them, especially if the token is for use for some other thing, as Palley wisely put it, the product and not the financial product. So I think that we have to be straight with clients, and I think that everyone on this call who deals with this is absolutely straight about where the SEC comes out on these issues. And I don't think that they're right on the law. I don't think they should be right on the law, but that is currently what they think. And we're doing a disservice to our clients if we don't warn them about that and then try to come up with the best way we can to deal with the SEC's somewhat irrational views on the subject.
Yeah, and I want to, one thing that constantly irritates me is I see the SEC from time to time criticizing gatekeepers. I mean, this gatekeeper has turned away millions of dollars in business. It would be really easy to take a lot of work, but they have made it impossible to not say anything but no often. Or it's not no, it's you can do that, but let's talk about how you're going to register. Let's talk about Reg D, Reg S. So let's talk about, can you register as a sort of a public security? And the answer to a lot of those questions is, well, that defeats the purpose of the product.
Yeah.
But I think most of us say no more than we say yes.
Yeah, Dave?
Yeah, a couple thoughts to add. I think there's and I agree with the bulk of what's been said. I think there's a little bit of a catch-22 with token issuances in the US, which is, at least in the SEC's view, under the 2019 guidance that they promulgated, for a token not to be a security, ultimately there has to be a project that is sufficiently decentralized that does not have a quote unquote active participant. Well, you can't go and issue a token just having it come from a broad-based community. There has to be some driving force behind it. So ultimately, tokens start life having a project team behind them. And at least in the SEC's view, that the tokens themselves, as opposed to the offerings or securities, it's sort of like hard to decouple all of that, which is why I think we've seen the nexus of activity shift outside of the United States, with the possible exception of some things like airdrops. I mean, I think most of us would take the view, and I think it's well articulated in the DLX article, which everyone should read, which is really like an outstanding overview of all the Howey jurisprudence. I think most of us would agree that a traditional ICO, if you have a retail-oriented token offering that you're selling to the market and saying, hey, this is an investment, that would be a securities offering. It's sort of a technical issue, whether it's the tokens themselves or the overall transaction, which is the securities offering. But I don't think anyone is disagreeing that something like that would be a securities offering. Where it really matters, though, around the nuance is if you take the view that the tokens themselves are securities, there are a tremendous number of downstream effects. So for people like Christine at Coinbase, well, if all of a sudden you find out through an insider trading case like Wahi that the SEC thinks that a token that you list is a security, there are knock-on effects from that. And maybe you as the issuer, you have to worry about 34 Act reporting under 12G of the 34 Act. So there are all these like different downstream issues that come from that little nuance. I can understand why the SEC would like to take the view that tokens themselves are securities, because it puts everything into a very familiar universe. And that brings us back to the discussion we were having a little while ago, which is that we need to have basically just have a clear rule set for all these things. That can be a new rule set, that can be tailoring an existing rule set so it fits this asset class better. For example, the purse safe harbor, in addition to Reg X, which I think was smart, would have very tailored disclosure for assets of these types. Like I think that actually for all the kerfuffle that is like nonstop here, people don't fundamentally disagree that we need investor protection, that we want to facilitate capital formation, that we want to not have people jump through ridiculous hoops in the United States where they're driven offshore. So I think there's broad alignment on those goals. We just have to kind of pick a path, either, fix an existing path or forge a new one. And with that, I'll turn it back over.
Thanks so much, David. Yeah, I just want to emphasize the article that you mentioned. You called it the DLX article, and I think if you go into LinkedIn or Twitter, you'd find it that way. But the actual name is called, it's very long, it's called The Ineluctable Modality of Securities Law, why fungible crypto assets are not securities. And what the authors did was they looked at, now I can over 200 progeny cases that considered the Howey analysis. And they couldn't find one case where the object, like the oranges, or anything, was considered the security. In every case, the investment contract was actually the transaction, the scheme, and it was always backward looking. It was never forward looking, as we're trying to do here. And the essence of the article is that this current analysis is just not correct, and it's being misapplied, and it's being misapplied so much so that in fact the SEC has usurped power that it doesn't have, and that actually made its way into a brief under what's called the major questions doctrine in the Ripple case. So I personally think this is a very good analysis, and I'm hopeful that judges, when they read it, will go, yes, it's not convenient and it's not effective and it makes things harder for everybody. But yes, this is actually correct. And thank you to the tiresome attorneys who read every one of those cases and cataloged them and did this very deep and thoughtful analysis. So we'll see. We have some good questions here, and I'm just going to throw them out in no particular order. So the last one, actually, one of them says something, talks about liability of developers. That comes up a lot. And we talk about, will the lawyers be held liable if their clients, if they don't protest enough, right? Will we as the gatekeepers be held liable? But what about developers? Does anyone have any thoughts there?
Kind of depends, doesn't it?
I guess what role they're playing, right? Are they doing more than just writing
what
code?
the developer is or does? I mean, there's a decent body of case law that applies in the US that applies 402A, strict liability, or negligence, sort of common law negligence theories to creators of software. I have a hard time with the notion that the developer of free and open source software is liable to unknown, is or will be liable to unknown third parties. You also have the economic loss doctrine, which would but if you think about it like anybody who went to law school, it's the Pallsgraf case and foreseeability. Slipping on the train platform, whether that was foreseeable to the Long Island Railroad. I mean, there's the problem of who the foreseeable plaintiffs are. I don't see as a practical matter. I know what's her name, Professor Walsh. In North Carolina, Arizona, her concept of the developer fiduciary is actually being litigated in England in the Craig Wright case. I don't think I don't think that model easily applies. But this goes back to, like, not to bring my own obsession into this, I think what we're going to see over the next decades is the development of a body of law that does apply to people who write code and create code. For right now, where things are, as a litigator, the idea that somebody could sue a developer who posted code in GitHub and went away and the code is broken, I think you have a very hard time making a case.
I do think it depends on what the code is for, and we've seen a little bit of case law in the middle here. So there is indisputably a First Amendment right to create code, to write code, and to publish code. But there is no First Amendment right to violate securities laws or commodities laws. And those two principles are in tension. So there was a case in Chicago where a bunch of programmers designed software that was essentially for the purpose of spoofing and layering and manipulation in commodities markets. And they were sued both by the Department of Justice criminally as well as by the CFTC. Their defense out of the box was to say, well, it's, we have a First Amendment right to create this code. And I think the governmental authorities and judges were very skeptical of that.
But in that case, were they using the code, or did they just write it?
They were no. See, they sold it. And this was a big factual distinction: is they were selling the code to people, basically saying, "Hey guys, use our code to manipulate commodities markets."
Yeah.
And
but twist
that's
those,
obviously a big
but
no-no.
Twist those facts and would the same debate be had if they just simply posted it on GitHub?
And I think there the answer would be radically different if they posted it. And now, if they posted it and said, "Here's our code, which anyone can use to manipulate commodities markets," and it had no other purpose, maybe that's a problem. But if they posted code that was sort of for a general applicability for legitimate or lawful purposes, that then was used for illegal purposes, that's something where you've got both the foreseeability polygraph issues, as well as more First Amendment kind of rights. I mean,
tornado cash.
Yeah, exactly. Tornado cash, PGP. This is exactly the right thing. So, I think you have a right to read the Tornado Cash code, to even publish the Tornado Cash code, but you're not supposed to be using the Tornado Cash code. So I want to send T-shirts to all my friends that has the Tornado Cash code on it that just says code is not illegal.
Hey, I want to throw a question to Christine. I think was one of the questions that came up, and just sort of reading with a crystal ball. Do you think that the tokens will, likely be regulated as commodities? Do you think they are more like commodities or something else? Just your take on that.
I mean, in an ideal world, I think yes, and this is assuming it's sort of commodities with like a digital asset overlay on top of it, so it sort of supports the market structure and function that's evolved today. 24/7 trading, real-time settlement. I don't want to sort of inherit the sort of challenges in the existing derivatives and securities ecosystem and sort of like lay them on top of the digital asset marketplace. But yes, because the commodity regime is really designed around sort of the consumptive element and utility of the tokens, and focuses on the underlying trading of that market and the and sort of the characteristics of that token, and sort of like explains to consumers, to investors, here's what you're getting when you buy this token, and here's sort of generally how the market for these tokens trade. I think that's much more applicable than an S1 that's going to just give you, to Sarah's point, just gives you a whole bunch of information that you don't need, and it's completely irrelevant. So, sort of in terms of first principles, the commodity market is I think the right regime for these assets. And I think the disclosures and the self-certification process is much more sort of appropriately tailored to the nature of these assets than the securities regime. But again, that being said, it's the Commodity Exchange Act of like 1936. Would love to see some sort of innovation and developments that support the current market structure, sort of, so you have those foundational principles, but something that's tied to like a 21st century market.
Thanks, Christine. Does anyone else have any comments on that, or anything else that they would like to add? Nope. I will. I'll take another question here. Let's see. Excuse me. So I think one person asked what they think that what do they think about folks who are, their clients coming in? Do they think they're fairly sophisticated? Are we seeing fairly sophisticated founders who are coming in, or are we still seeing the same bright-eyed?
That's a big mix.
It's a mix. I joked, I get these inbound emails like, want to create a DAO that's going to issue NFT governance tokens so that we can go buy uranium certificates and We want help figuring out how to get money to be wired to banks and turned into stable coins. And I mean, but there are plenty of sophisticated folks out there. I will also say there's a lot of dry powder. There are a lot of people with money who are looking for deals. I've started to see that in the last, almost immediately, people contacting us and saying, hey, looks like there's some good tech out there that might be available for cheap.
So what do we think about DAOs? Do we think that, given the ongoing litigation in the Oki DAO case, I know some of you may be involved, but and the recent ongoing the dispute over service, whether or not service was proper in posting. We have the CFTC, they posted in the chat. Does anyone have any thoughts on that one way or another?
I have a lot of thoughts about. I just filed a reply brief.
I have a lot of thoughts about
it.
Anyone have any thoughts they want to share?
Oh.
No, that's funny.
So I mean, I'll venture to say that 2022 is definitively not the year of the DAO. I recently was talking with Dane Lund about all the different structures, because the term DAO, there's a lot of words that we use in crypto that are just don't even reflect the reality, right? Like you have and I'm picking on it, and as usual, the Wyoming DAO LLC law, which I just had such a hard time with the name, because you don't just simply say I'm forming a decentralized autonomous organization, I'm filing. No, you can't do that if you're a DAO, right? You're not retaining a lawyer. So there's the big question is autonomy. And there's not a lot of reflection. People just use the acronym. And I think part of the problem too is that the Hinman test sort of forces people to try to always achieve this notion of sufficient decentralization. And one of the things that the ineluctable modalities, I'm not even going to say the whole thing, really points out, and was this mind-blowing moment for me, because he really, they really take apart the Hinman argument and show how it was a warped interpretation of the investment contract analysis, that actually, that could be an indicia of what would not be regulated as a security, but that's not actually the test. It was just sort of like a derivation of a test that was warped. And in fact, the ineluctable modalities presents a much more logical interpretation that's aligned with case law, which Hinman did not. So, you have DAOs. But a lot of people who say they're DAOs, they're not actually DAOs. A lot of layer ones are DAOs, but most DAOs aren't in fact DAOs. Then you have DOs. DOs are decentralized organizations, and a lot of times they're not even fully decentralized. So they're effectively O's, and they're going out saying that they're DAOs, and they're not saying that they're DOs. They're just saying, they're not even saying, but they're really O's. And there's a lot of exposure that results in that. And I do think DAOs become much more significant in the future, particularly as we start to contemplate AI having these governance decisions as a way of sort of reviewing and facilitating and sort of acting as sort of an overarching structure over AI-based decision making. Because really the idea is not to have all these decisions made by people, but to have them made through through code. And then that's the ultimate. I don't know if that's the ultimate objective, but that's certainly one of the things that you would think a DAO would ultimately want to achieve. So anyway, I'll stop there.
No, that's great, David, please. And we're going to be
I'll add to that.
shortly.
If we're going to have decentralized systems that we're going to rely on for important functions, they should not be like a ghost ship that is just floating around with no one driving it. So you need some kind of governance over decentralized systems. People don't talk about Bitcoin as a DAO, but you could argue that Bitcoin is a DAO because the Bitcoin code can be updated, and there's a consensus mechanism whereby that happens from people that run nodes, and there's a logic to that. So I think we don't want to disincentivize the ability of a collective to be able to upgrade the functionality of decentralized software, including upgrades that could prevent nefarious use of different kinds. As one example, like Uniswap blacklisted particular tokens that would have been effectively tokenized securities like of traditional companies. So I think that we ought to have policies that don't discourage this kind of activity. If you start imposing individual liability on people who vote DAO tokens, That would be a deterrent to most clear thinking people. Now, there are ways to mitigate against that by having so-called legal wrappers that could insulate people from individual liability. But again, all of that is really stuff that we're seeing offshore for the most part. Notwithstanding the Wyoming DAO laws and some other states in the US, you don't really have a critical mass of DAOs here. And I think that it's something that requires further examination. There may be other states like Andrea, one that's near and dear to you is Delaware, that there might be possibilities of using LLC laws. And so I think this is something lawyers should really continue to explore.
Yeah. So in the last, we just got a question, and I think it's a really good one. And we'll use that as our parting question. What's going to be keeping you busy in the next 2 years? Are you going to be looking at compliance? You're going to be litigating? You're going to be like, where's your attention going to be focused? Let's just do a quick round robin, like a few words. David, you look like you're in mid thought, so I'm gonna let you finish. And everybody just take it around, and that'll end up the.
Well, I think in the near term, there's probably a lot of distress in the market. I think longer term, we'll see a healthy mergers and acquisitions activity, and the space will survive its current.
Oh, good. We will survive. We should need the music in the background. Sarah.
Yeah, same. I think that like in 2023, we're going to get some sort of legislation, and a lot of people are focused on playing defense, possibly trying to push for DCEA if that's possible. I'm personally waiting for if Reg ATS ever happens, and like a fight for that. That is constantly on my mind. But I think just a lot of advocacy is on the forefront going forward.
Steven.
I think we'll see products, real products. I didn't come to crypto because I'm a terrible trader. I'm actually a good counter trading indicator. I think maybe we'll see. And I mean, no offense to folks who find it interesting. It's not that I don't find money interesting. I find sort of financial arbitrage kind of dull. I think we'll actually start to see good product. That's my hope anyway.
Okay, Christine. Thank you. Thank you, Stephen. Christine.
Policy, legislation, regulation, and enforcement.
Yeah, great. Eric.
You know, I see the next few years as, you know, obviously there's going to be a lot more building and tooling and trying to figure out a way to take all this technology that we've developed. And in many ways, I think there's going to be, maybe I shouldn't even use the word morphing because I don't mean it in like a securities analysis, but there's going to be a lot of, you know, we're going to change the way that we talk about crypto. We're going to change the terms that we use to talk about crypto. Crypto or digital assets are going to find.
I got to put in here. I got to stop you. You're being very aspirational. I love it. Aspirational about the way we talk. Jason.
No. My point is simply this. My point, and thank you for hemming me in. My point is simply that what you're going to see is it's seeping in into a lot of businesses and a lot of frameworks that may not seem as obvious, may not seem as aligned with the way crypto has developed to date. It's just going to be different, and I think there's going to be a lot of changes that come, and I think it's going to be an exciting time to build. But you have to sort of be open and you know, to how blockchain technology is used. So anyway,
we're on time, Jason.
I know.
The last few words, and then I'll wrap it up.
I come at this from the backwards facing view, litigation and enforcement. I mean, fundamentally, things come to me after they have already happened. So I love the forward thinking, policy focused nature of this group. I'm going to be cleaning up the mess over the next few years. And my biggest hope is that the rules are made by everyone else pushing on the rulemaking and policy side, and not whatever comes out of what we're doing, because our rules are going to be less good than all of your rules.
Hey, I want to, so this is a wrap. I want to thank all of you on the panel for joining today. I want to thank Riley. I want to thank the GBBC and the International Journal of Blockchain Law. Thank you again, and have a beautiful day. We're done.
Thanks.
Thanks, everyone.
Bye-bye.
Thanks, folks. It was fun.
Bye.